know that before the break, I was especially interested in hearing what Austin had to say, although I haven't been in the market for a hot tub. I have followed the Wall Street Journal's coverage of the supply chain and was very distressed personally more than a month ago to learn, after putting down a huge deposit on some appliances, that they may not be ready until May of next year. But in any event, enough about me. Want to remind everyone that if you have questions about any of the topics, please type them into the Q&A box on your screen. And if for some reason we don't get to your question or you think of it later, please be sure to include your email address, and we'll make sure that one of our Foley attorneys gets back to answer you. First up, speaking now, is Bobby Howell, who obviously needs no introduction, but she'll be speaking on the subject, repair or replace the weak link when distributors and dealers are the problem.
Thank you, Mike. Good afternoon, everyone. Again, welcome back after the break. So we're going to talk this afternoon about a slightly more traditional, if you will, distribution topic, which deals with terminating distributors. And this is going to be the first in 3 presentations that we'll tie together. I'm going to talk to you a little bit about sort of the practical and legal realities that you need to be thinking about before and at the time that you decide that you need to terminate a dealer. Following my presentation, Tim Patterson is going to talk to you a little bit in more detail about the different statutes and the fact that you may not realize that you are actually even covered by some statutes that you need to take into account when you're in this position. And then following that, Connor Sabatino is going to talk about some of the legislative activity that we've seen and the kinds of things you should keep an eye out for on the horizon, as these various dealer statutes that Tim is going to be talking to you about are the subject of a lot of activity at the state level in particular, particularly from dealer associations. So next slide, and we'll jump right in here with the termination issue. And the title of the slide might be a little bit of a surprise to some of you, when we say termination should be done carefully, if at all. Oftentimes we get phone calls from clients, particularly who've not been through the termination process before. Business people are really pushing the in-house lawyers to get a dealer terminated sooner rather than later. They think it's a no-brainer. Our contract says we can do it on 30 days notice. It's 4 o'clock on Friday afternoon. We got happy hour scheduled at 4:30. Let's get this letter out and get on with life. Well, that's really not the way to do this. There are both practical and legal reasons for that, and that's what we're going to talk about today. But if you do this properly, you will minimize the disruptions to your business, which frankly should be the most important consideration, and is probably what the business is trying to get at, but does not realize that the sort of quick draw McGraw approach to things is really not the way to do that. Sorry, showing my age with the quick draw McGraw analogy, I apologize. And we want to make sure that if you do end up in litigation, you will minimize your liability and you will maximize the potential to be successful in that endeavor, because litigation is oftentimes what happens after a notice of termination is filed, particularly if the termination is not handled properly. And most importantly, even if there's not litigation, you want to maximize the likelihood of a smooth transition for both your business, for your customers, potentially downstream customers, et cetera, and suppliers in some cases. But you need to think about a number of both practical and legal considerations when you do that, and that's what we're going to talk about today. So let's go to the next slide. I want to talk first about the human context. Oftentimes, I've heard people say, oh, it's just business, people shouldn't take this stuff personally, et cetera. Well, maybe, and I use maybe with emphasis, maybe that's true if you are involved in a very large corporation where the particular business that's at issue is not, the focus of your particular bonuses or something along those lines, or you don't have to report at next month's analyst call. But for the most part, it really is more than just business. It is often personal, and this is particularly true where you're talking about dealers and distributors who may be small businesses. It may be a family-owned business. The idea that somehow this business that they've spent many years developing or investing their life in suddenly may go away, that's personal. And in many cases, it may be a surprise. You may not think it's a surprise. The business folks may say, oh my God, this can't possibly be a surprise. We've been complaining to this guy for years about his performance. Well, you know, human beings being what they are, we tend to ignore things that are not comfortable. And we're very good at not catching those clues, even when they should be sort of big red flags waving in front of our faces. And so it may be a surprise, in fact, to the person who's hearing about it, and it's not going to be a happy surprise. And so that obviously has all kinds of human interactions, human responses, et cetera, that go into this. And you can't just look at this as a purely dry legal thing that you read in law school and in a case book. This is a real human situation that you need to be addressing. You also need to think about the human piece of this if you do litigate, because when it comes down to at the very end, it's going to be a judge or a jury that's going to decide if you did this the right way. And you want to make this as easy for them as possible. The judge will presumably and almost certainly, but almost being an important word, understand all of the rules and all the facts, and they will be paying attention. The jury may or may not. I mean, those poor people are sitting there hearing about this stuff for the first time, may have no background in business, certainly are not going to understand the legal rules, and they're going to be taking a lot of information in a very short period of time, and they need to make a decision that's going to have pretty significant consequences both for you and for the dealer that's involved. So you want to make it as easy as possible for them to be on your side. Next slide, please. And what I always tell people is to put themselves in the context of that jury and ask themselves next slide, please. There we go. And ask themselves the question, is it fair? Because that's the question that the jury is going to be asking themselves. Is what happened here fair? And you know, lawyers will give you all the legal rules, and we're going to talk about all the legal rules today. But in the end, it's that visceral reaction that the jury is going to have, asking is, what happened here fair to the dealer? And that's what you want to be able to put your best foot forward and explain to the jury if you want to be able to litigate this in a way that is going to be successful. Next slide, please. So the first thing I want to talk about is what I would call an ounce of prevention. And this may be counterintuitive, but I think you want to set yourself up for doing this as successfully as possible from the very beginning. And the way you do that is you make sure that you don't enter into dealer relationships sort of willy-nilly or without thought. You want to do it carefully. You want to have clearly drafted contracts. A lot of people, oftentimes folks who've been in a particular business for a long time where formal written contracts may not have been the norm in the past, or may not always be carefully followed or administered, will, you know, tell you it's all about the relationship and it's all about a handshake deal, and all that's true until that relationship falls apart. And so you really do want to make sure that you have chosen the people you're going to do business with carefully, and that the expectations that each of you bring to the relationship, both as to what you're going to do and what you're going to expect from the other side, are carefully laid out in a contract. And that doesn't just mean writing a contract once and then sticking it in a drawer and forgetting about it until it's time to terminate or to take some kind of adverse action. You want to do it in a way that you are updating it regularly. Think about the things that have worked, things about the things that haven't worked. Think about how the world has changed and how you might need to adjust your contracts accordingly. A common example I give is that it was a very big deal for one of my clients in their dealer contracts a number of years ago to make sure that their dealers had approved Yellow Pages ads. Well, you know, that's kind of not a big deal anymore. Many people don't even know what a Yellow Pages is. And they, you know, updating their contracts was an important part of that process, you know, adjusting to how the websites are handled and how they're dealing with e-commerce and other ways in replacing that telephone directory reference. Those are the kinds of things that people don't think about, but can become important later on when you want to have a problem with the dealer because the way their website is being handled is not done properly, but you don't even have a reference to their website in your dealer contracts, for example. So you want to take all those things into account. Next slide. Once you're in the relationship, however, you've chosen your distribution partner, word lawyers shudder at, but which is used all the time in business. You've chosen that person who's going to work with you. You've put out a good contract. You've got your expectations, but now you have to manage that, and not just the one, but your entire network. And you need to do it strategically and carefully. Again, both to make sure that your business is running well on a day-to-day basis, but also in the event that you do have to take action, you want to be setting yourself up to be successful. One of the ways you do that is you set and you enforce reasonable performance requirements. That can't be overstated, because lack of performance is the #1 reason why manufacturers want to terminate relationships with their dealers. It's important to sit down with those dealers on an annual basis, or however often you're going to measure their performance. Make sure that you've taken into account things you may not know about their micro market, if you will. You may know a lot about the market on a nationwide basis, but you may not know about important things that have happened in their region or their state or even their county in some cases that may have a significant impact on their ability to perform. You want to know about those things so that you can get out ahead of them from a business perspective, but you also want to take those things into account when you are setting performance goals, because if you don't and you try to then later terminate based on their failure to hit the performance goals that were set, you're going to have a very difficult time. So make sure you're meeting with them regularly, make sure you're updating them, and make sure that you're enforcing them across your distribution channel. You want to make sure you're enforcing the requirements of your contract even-handedly. You don't want to give somebody a pass on a particularly important requirement unless there's a very good reason for it. Again, remember that the question that's going to be going through the minds of the jurors, even though it will never show up on a jury verdict form, is what you did fair. Make sure you are being fair in the way you're treating your dealers, both in general and with respect to each other. Maintain good records. I can't overstate that enough either. To this day, I will have conversations with clients where they want to take some action. My first question will be, can I see a copy of the contract? And I think probably still 10 to 15% of the time I hear, well, we're not sure where it is, or it's been signed by so-and-so, but not by both parties, or, well, we think this is the contract, but there might have been an update, we're just not sure. It happens, unfortunately, far too often. Makes it very difficult to make sure that you're proceeding appropriately and doing it in a way that's going to best serve the goals that you have here. So you want to make sure you do that. It's also important, and I know these are out of order a little bit, but both the performance improvement and the training your field folks for professional behavior, those two things really do go hand in hand. If your field folks are out there and they don't particularly like a specific dealer, and then as a result, they're not treating them quite appropriately, they may not be giving them the same coaching, they may not helping them develop their performance, etc. And then come down the road, you have to make a determination about terminating that relationship. That's going to be a problem. It's going to be, that person is going to be front and center. Their behavior is going to be front and center, and it's going to be a problem for you as you go forward. So you want to make sure your people are trained. Even doing something as simple as giving them a primer on what we're talking about right now, how terminations need to proceed, why it's important to do it in a certain way, can be an important and effective way to help them model their behavior in a way that will serve you in good stead, both on a day-to-day basis as well as in the event of a termination. Next slide, please. You also need to make sure that you are considering alternatives, and that may sound strange from a lawyer whose job is sometimes to write those termination letters and to litigate when there's a dispute about it. But it's important from a business perspective to really think about what the alternatives are, because it may be the fastest and least expensive way to meet your business goals. Think of it as the lesser of two evils, if you will. The best way to do that might be to rehabilitate the dealer. Maybe there's a good reason for the dealer's failure of performance. Maybe it's not a great reason, but it's something that can be fixed. That's going to generally take you a whole lot less time to do and will oftentimes have side benefits that a termination may not. You may be able to appoint another dealer that can pick up the slack in the territory. If your dealers don't have exclusive territories and you don't run into a problem with a substantial change in competitive circumstance statute, which you'll hear about a little bit later, you may be able to do that fairly easily and fairly straightforwardly. You might be able to simply modify or narrow the contract territory or products that the underperforming dealer is covering and appoint somebody new to take over the other pieces of it. Maybe you can negotiate a voluntary termination. Maybe that dealer, the reason they're not performing is because their heart's just not in anymore. Maybe they're nearing retirement. They don't have someone to take it over. Maybe there's other aspects of the way the market has changed for their particular region, and maybe there's just not enough money in it for them to put the focus on your product that they should be, and maybe you can fold it into another larger dealer nearby by working out a voluntary termination. Maybe the dealer really just wants to sell, and if you can go help them find a good buyer, that will serve you in good stead. It's somebody that you already know you want to do business with, etc., and you can help that dealer get out of the business without losing that investment that they've made. And last but not least, sometimes the best alternative is to take no action. That's pretty unusual. Usually by the time you've gotten to the point you're having this conversation, performance is bad enough you need to do something, but it is not something you should ignore. You should at least consider it before you take the next step. Next slide, please. So once you've identified what the possible alternatives are, you really need to kind of weigh the pros and cons. Are you likely to solve the problem with that alternative, or not? And if you're successful, what is it going to cost you to get there? Is there going to be a continued period of underperformance? What is the cost of that? You're going to have some lost revenues. You may have some lost market share. How long is it going to take you to fix that, to get it back? And weigh it against the potential downside if you lose, and what the cost might be if the time takes even longer if you have to litigate it. There are some real benefits to these alternatives as well that sometimes get lost in the shuffle, particularly if someone has been underperforming for some period of time and people are kind of fed up. They don't really want to think about what the benefits of rehabilitating that dealer might be, but there are some. It can be an important way to keep customers long term. It can minimize your disruption in your day-to-day operations. Turning over to a new dealer, getting them trained is not a small undertaking. It can develop some significant channel loyalty where your dealers realize that this is not an us versus them, but we're in it together. And it can really generate some loyalty as a result. Next slide. There are some costs of termination that you also need to consider. There might be unpaid invoices you would never get paid. We talked about lost sales and market share. Management time that will have to go into dealing with litigation can be pretty significant, and you may have some issues with channel goodwill, sort of the flip side of the loyalty that I talked about a minute ago. Next slide, please. Some things can't be fixed though, and you're going to have to take the next step and terminate occasionally. Some of the kinds of things that can't be fixed, and you probably don't want to think about the alternatives for too long in some of these cases. If you've got a dealer who's committed fraud, submitting fraudulent warranty reimbursement requests, for example, not just mistaken, but fraudulent ones, that's a big problem. That is a serious issue that needs to be addressed right away. Failure to pay, particularly if they're making sales out of trust, which is another form of fraud, those kinds of issues should be addressed right away. And in fact, not addressing them immediately can come back to haunt you if and when you decide to take the step toward termination, because the dealer will argue that you've agreed to that course of conduct and that it's really not such a bad thing. Sales of competitive lines can be a big deal if you have a non-compete in your contract. Criminal behavior is a significant issue, and it doesn't necessarily need to rise to the level of a criminal issue. Had a client who not surprisingly had to get rid of a dealer last summer when, right in the height of all of the racial justice protests, this dealer was putting significantly racist rants on its dealership Facebook page. Those kinds of actions sometimes require immediate action. So things like that you need to be aware of, and you need to take action pretty quickly when those occur. Next slide, please. So what do you do when you need to act? Well, you want to, again, put your best foot forward. Again, I'm showing my age. We've got our friends from Dragnet on the slide there. You really want to get to the facts. You want to do some preliminary investigation and analysis, and there's a pretty detailed checklist in the written materials for the presentation today that kind of give you the things to look for. But you want to gather and review the documents. You want to interview your internal personnel. You want to confirm, trust but verify, another phrase, but one that's really important. You want to make sure that what the business people are telling you that are the reasons for the termination are in fact the reasons for the termination. And you want to essentially cross-examine them, because that's what's going to happen to them by the lawyer on the other side if there's litigation. You also want to think about what the legal issues might be. Do you have a written contract? What does that require? Are there oral promises that came after the written contract that might modify it that you need to take into account? You're going to hear a fair bit from Tim in the next presentation about the state statutes that might impact that. You need to take that into account. And you need to think about whether that dealer might have some counterclaims that might make litigation even more uncomfortable than it might otherwise be. Are they going to make antitrust claims? Are they going to claim fraud in the inducement? Are they going to be making tort claims where they're going to be asking for punitive damages, for example? You want to take those things into account. You want to make sure that you vetted the facts so you feel comfortable knowing what you're getting yourself into. Next slide, please. Then you need to send the notice, and that's been a long buildup, I know, for 20 minutes to, okay, now we're going to send the termination notice. What do we have to do? There's a lot more that goes into this than just sending out a letter that says, hey, you know, pursuant to section so-and-so of the contract, we're terminating our relationship 30 days from today. You know, we appreciate the work you've done over the years and wish you the best. I mean, that's in some cases that might work, but in a whole lot of them, and in fact, most of them, that's not going to be sufficient. You need to be aware of the timing that's required by your contract, and there's probably a statute that will also have some timing requirements. Both your contract and your statute will tell you whether you need to have cause and what is sufficient cause for sending out that notice. You may need to give that dealer a right to cure, and that the time for that can range from as little as 30 days to 2 years in some cases, depending on the reason for the cure. You may also have a shortened period of time when you can terminate if the reasons for the termination are, for example, going dark, or a loss of a license that's required to operate, etc. So timing is an important consideration, and you need to make sure that you are taking the contract and the statute and any other requirements into account, and you are putting them together and making sure that you're complying with all of those obligations. And last but not least, I don't want to ignore this, but you don't want to ignore the requirements for delivery. I actually had a case a number of years ago where the client who had sent out the termination notice before they came to us, we ended up having to litigate the case. And it turns out that they were required by their contract to send a letter by certified mail, and they didn't do it. And the court said the notice was not sufficient and refused to, while they had good cause and all the other things were there, without that notice that was insufficient, we spent a lot of money on litigation because nobody was willing to come to the table on either side. And ultimately they lost because they had failed to send the notice in the appropriate way. So it's something you shouldn't ignore. Last slide, or I'm sorry, next slide. When it comes time to, once you've sent the notice out, you also need to make sure you manage the transition. So, sales representative statutes often have a lot of things about when you need to make sure you're paying commissions, for example. Dealer statutes often have inventory repurchase requirements. You may have to deal with how existing warranty claims are handled, a whole number of things that are involved. And at some point, you're going to have to inform your customers. And when you do that and how you do that will depend in part on why the termination is occurring, how long the transition period is, etc. But all of those things need to be handled carefully so that you don't get to this point and have everything handled okay, and then somebody says something dumb when they're reaching out to a customer to explain the transition, and that then causes somebody to say, hey, wait a minute, here's a problem. And then last slide. This may seem self-evident, but unlike Marvel movies, you should not have a post-credits scene here when you're dealing with terminations of dealers. Once the termination is effective, based on what your notice says, you need to stop doing business with them. There may be circumstances where there's going to be some continued interaction, inventory repurchase being one, but don't continue to fill orders. Don't continue to have people sending customers to them for product. You need to make sure that you are managing the transaction and you are managing the transition so that when the relationship is effectively ended, it really, in fact, does end. I see we had a question because that is the last of our slides and I'm running out of time here. So I'm going to just take a quick look at that question. And it says, when you say you should treat dealers fairly, would that also extend to contract language? Would you recommend keeping your contract consistent across the board and reject any change requests from dealers to keep contracts consistent? Or is it more important that dealers are treated fairly as it relates to performance and not necessarily contract language? That's a really good question. And it could be a whole 20-minute presentation on its own. But the short version is, I think it extends to all of those things. If your contract language is very one-sided and you have to then defend it later on, particularly if you're holding people to the letter of it, that's going to be problematic. If you have specific good reasons why you need to manage contract language and make a difference between dealers, that might be a good idea. It may not. It's not one of those questions you can answer sort of in the abstract because it's really going to depend on the reasons for the differences. And unfortunately, fairness is not something that, you know, there's one definition for it. Believe it or not, I actually had an entire upper level undergrad political science course on the issue of equality and fairness, and really there are a lot of different ways to measure what's fair and what's equal, and that's unfortunately not something where we can draw bright lines. And it has to take into account all the circumstances. So generally, you want to have your contracts as similar as possible. That makes it easier to treat your dealers equally and fairly. But there are always exceptions that prove the rule, and you're going to just have to deal with that sort of on a case-by-case basis, both in how the contracts are drafted and how they're enforced and administered.